Obviously, there's been big changes. Happened midnight on New Year's Eve, probably when a lot of you were reveling or doing something or other. And this is the new regime. It's kind of been planned for a while. Anne's introduced me something you probably know enough about that. So we're talking about GDPR post-Brexit, but not just post-Brexit, post-transition as well. So at 11 p.m. on the 31st of December, the UK now, as far as data processing is concerned and handling personal data, is classified as a third country, and that's a term devised by the European Union to determine somebody who's not part of the Union and not part of the European Economic Area. The UK government can't agree on lots of things, such as the Euro-atom that we can't be a member of and things, but what they have said is that we will continue to apply GDPR, and we've renamed GDPR to UK GDPR. So make a mental note there, because documentation will need updating to reflect these changes. There is still, although there was a transition period for trade, and I don't want you to confuse trade with data flows, because the two are not necessarily intertwined. So for data cooperation and data flow, there is what's called a transition period, which is 6 months. So this is all to do with the flow of data. So we have 6 months to change things. And what effectively we're working towards is for the EU ruling that the UK meets something called adequacy. Adequacy is a test that is done on countries to decide whether their data protection regime meets adequacy. So you might be surprised to know, but America and Australia do not meet adequacy. And therefore other documentation needs to be put in place. And I'm going to show you and talk you through that documentation, because it has a bearing if you have a head office in America or a subsidiary in Europe. There is further things you need to do, but we will talk about that. So effectively, this was all part of the Withdrawal Act. So UK GDPR now sits alongside the Data Protection Act 2018. So don't confuse it with earlier data protection legislation, which has been repealed. There is also something out there called the Privacy and Electronic Communications Regulations, PECR, PERSA, as people call it. The main thing to understand is, as far as GDPR is concerned with regards to the UK, there are some minor technical amendments. For example, by incorporating it into domestic law, it's accountable now to Parliament as opposed to the European Union. It's also just worth saying that because the original legislation was a regulation, GDPR was actually read directly into domestic law without the UK having to do anything. That's the same for all European regulations. So there was a domestic piece of legislation that went through, and we now have UK GDPR enshrined into domestic law. Now, the thing to understand and get your head around is that UK GDPR only applies to the United Kingdom and Northern Ireland. It's therefore not necessarily recognised by EU member states. So until we have that ruling on adequacy from the European Commission, we're in a transitional stage for data sharing, and we've got this 6 months transitional period during which you can continue to share data within the European Union and receive data as you have previously. But within that 6 months period, we're hoping that adequacy will be reached. If adequacy isn't reached, then there will be issues. So as a consequence of that, the European Data Protection Board is no longer the ultimate organisation in charge of regulation. It's now the Information Commissioner's Office, the ICO. And they are the supreme body now within the UK for maintaining data protection and also managing this transition period. So the UK government has made it very, very clear it's committed to high data protection standards, and we do envisage further tweaks bits of legislation when Parliament gets back into its stride post-COVID. So just this was all done by a statutory instrument. This is the piece of legislation. You'll notice 28th February 2019, and it basically said the minute we left and the transition period ended in terms of whether we'd reach a trade agreement or not, this would become enforceable. And you'll see right down there, it mentions 2018. It also mentions UK GDPR, which is all now read into domestic law for England, Wales, Scotland, and Northern Ireland. So what's the big difference then between GDPR and UK GDPR? So to be honest, there isn't much difference because it's the same legislation, other than you've got UK in front of it. So if you are GDPR compliant now, then you should be GDPR compliant under UK GDPR. But if you weren't compliant before, you certainly will be compliant now. So now's a good time, if you are concerned, to have a little audit. And if you need a big audit, we're obviously very welcome. You're very welcome to get a quote from us, and we'd be pleased to quote for them. Now, the whole thing in terms of moving forward is around this adequacy decision. And if it's not forthcoming, and there's no guarantee it is, a number of countries haven't met the required standard, but we obviously, if this is UK, will. If it doesn't, then other means of sharing data will be needed. But as I say, for the next 6 months, the EU-UK Trade and Cooperation Agreement applies. In terms of adequacy and third countries, so there are 12 countries that currently meet adequacy. So some of these are quite interesting. So New Zealand, well, fair enough. Argentina, okay, and Israel, Japan and Canada, but Uruguay also meets adequacy, which is rather strange because the United States and Australia don't. The US is a particular problem, and if you are sharing personal data or sending any personal data out to the US, whether under GDPR or UK GDPR, you do need to put in place standard contract clauses, because there's no other way now of sharing data since a legal ruling last summer to say that the United States did not meet adequacy. Just bear in mind also that it took Japan 2 years to reach an agreement over adequacy. So the European Commission, which determines adequacy, does not move that fast on these things. But there is, at the moment, no need to change anything in terms of how you send personal data to the EU or the European Economic Area, or indeed Gibraltar. These countries obviously in their own right meet adequacy, but the issue is that the UK is now a third country. So we have to rely on the transition 6 months until the ruling on adequacy is moved. So what happens if the UK doesn't meet data protection adequacy? Well, if that doesn't happen, then you will need to put in place some special documentation. So there are 2 lots of documentation available. One is called binding corporate rules, and the second is standard contract clauses. So binding corporate rules is designed for sharing data with a subsidiary. So for example, if you had an American owner, and your American owner wants to see your payroll data, you cannot, under GDPR or UK GDPR, share HR information, including payroll data, with a third country that doesn't meet adequacy, such as America, without either putting in place binding corporate rules or standard contract clauses if it's not if it's just a trading relationship. Now I'm going to cover these off in a little bit more detail because it's not fully understood. So the UK, this is the ICO, has actually developed some documentation, because the documentation was originally designed by the European Data Protection Board. So the ICO now has got its own forms, and you can download these from their website. And there is a document for standard contract clauses for controller to controller and controller to processor. And just for, I know most of you probably know this if you've attended any of my webinars before, but you, as the business owner, in inverted commas, are the controller of your data. So if you used a payroll company, for example, to process your payroll things, or you use MailChimp as an example, which HAE do for sending out mailer pieces, you are outsourcing the processing of that data, and therefore you're sending it to a processor. So if it's that payroll data you should have, and you were using anybody overseas in the US or a third country that doesn't meet adequacy, that the EU recognises, you should actually be using a controller to processor agreement. Now, some organisations, Google, Microsoft, MailChimp, have actually taken standard contract clauses and incorporated them into their terms and conditions. Because you can't actually modify standard contract clauses. If you modify them, they're actually invalid. The only thing you can do is put your name in and who you're sending the data to, you're sharing the data with, and you define them whether they're a controller or a processor. Okay, so I hope that's relatively clear. The other thing you need to be aware of as a business is that if you're dealing and processing a lot of data within the European Union, you will need to appoint a EU representative. And that's something, again, it's not that you need to have an office there or anything like that, but you need to appoint somebody who can actually represent your interests. So that's something we can do as an agency, but it's something that you can also organise through third parties as well. So let's just talk about binding corporate rules. So binding corporate rules are needed to transfer personal data between companies within the same ownership. So you can see that, hence the name corporate rules. So, you know, I do know that there are members of HAE who have a head office in Italy. I've done an audit on them. But I also know that there are other companies connected who have head offices in America and elsewhere around the globe. So if you are doing that under UK GDPR, and indeed under the old GDPR, you should have in place binding corporate rules. Once you put them in place, they're there. You don't need to keep renewing them or anything, but you do need to put them in place. And the reason they're needed is it's to recognise that data subjects have got certain rights. So the right to withdraw from processing, the right to object, the right to request what data you're holding on file. And these are all things that you will be familiar with as businesses, with data subject access requests in the UK. And if you've done work in Europe, you'll know that that's also exactly the same. But not all countries, it's legally binding. So to deal with that, binding corporate rules are put in place, and it basically means that the data subjects have got the right, same rights and privileges as EU subjects, but also it's legally enforceable through the courts, that they're able to challenge it. Now, binding corporate rules are quite fiddly, and they do need to be signed off by the Information Commissioner's Office. So you can't just fill them in for your two companies and duly sign them between you, and that's the end of it. They do need to be pre-approved, or as it says there, reauthorised by the Information Commissioner's Office. So do bear that in mind. There are forms on their website that you can download if you need to. Obviously, our guidance is available as well. The main thing is they're designed for third countries that don't meet EU adequacy, don't meet UK standards, and that is the only safe way you can share personal data. And if you don't do that, then the data subjects have got the right to challenge you in a high court in the UK, or indeed to seek an action against you through the Information Commissioner's Office. Standard contract clauses, these are the most popular, and they tend to be put in place where you're using somebody for processing your personal data, and you don't want them doing anything with your personal data, such as sharing it with other third parties, which would be a disaster, doing processing that you don't want them to do, or collecting data you don't want them to do. So standard contract clauses would typically say in there that it would lay down the level of processing and will only process in accordance with the written instructions of the data controller. but it would also stipulate in there that they have to delete the data after a certain period of time. They have to keep it updated to work and cooperate with the data controller. These are recognised by the European Commission, and since the 1st of January 2021, the ICO has introduced its own downloadable forms, and these are pretty much a copy. Plagiarism, I think, comes to mind, of the EU standards. Okay, so there is little you can do with them. They're sometimes known as model contract clauses, but you can incorporate them into other documents. So hence the reason people have put them, like MailChimp, into terms and conditions. So the big question is, how does this affect your business? So there's one of the things you need to be mindful of is, so when did you collect the data? Because before the 1st of January, you'd collected the data, any personal data, in accordance with GDPR. As from the 1st of January, you're now collecting data in accordance with UK GDPR. Which, as it suggests on the slide, sits alongside the Data Protection Act 2018. So you do need to make sure with your databases that you know when data was collected, because there are slightly different rules applicable. So anything pre-2021 is still governed, believe it or not, by the legislation that was in force at the time, which was GDPR. And that meant it had a wider scope because it was covered off by the EU, and anything post 1st of January 2021 is governed and regulated by the UK and Parliament. So just keep a note. Secondly, documentation. So all privacy policies will need updating. I hate it when companies have multiple copies, but I do know that some companies do have multiple copies, and there's a way of managing that, so you only have one copy and then you make reference to other documents, which I'd strongly recommend you look at. Secondly, you ought to look at a data protection impact assessment to make sure, having changed your documentation, that there isn't any risk to data subjects. And any other documents that you've got that make reference to the EU need amending and updating. So UK GDPR, interestingly, has a slightly bigger territorial scope in the fact that outside the EU, it applies to the rest of the world. So the UK are holding those standards right across the world. So if we're processing data from Australia, for example, UK GDPR applies. That doesn't apply in the case of the EU. So that's so you could do mailers, for example, to Australia. That's from a practical point of view. And it wasn't governed by UK GDPR. It wasn't governed by GDPR either, because the European Union didn't apply those standards to Australia. But the UK government have said it will apply these standards across the board. How else does it affect your business? Well, if you have a subsidiary business in the EU, you will need to have somebody who is recognised as your data protection officer. They don't have to be full-time. It's just a contact that an EU subject can easily contact. As we've intimated, if adequacy isn't met or recognised, I should say, by the EU, you will need to put in binding corporate rules and potentially standard contract clauses for exchanging data with anyone within the EU or the bigger EEA. What else do I want to tell you? So a data protection officer can continue to represent the UK and the EU, EEA, but you must make sure that your DPO is easily accessible. So what are the other changes? Well, we've already touched on some of these. So the thing is, within the UK, the lead supervisory authority is the Information Commissioner's Office. However, and this is where it gets tricky, if you had, for example, a subsidiary in the Netherlands and you wanted to share data with that subsidiary, you'd be having to share data using binding corporate rules in the next 6 months. If you did do that, the authority in the Netherlands, and forgive me, I cannot pronounce the Dutch name, but the Dutch equivalent of the ICO would need to sign off the binding corporate rules. So both the ICO and on the other side, the Dutch authority would need to sign those off. As always, data subject access requests, you must be able to handle them within the 30-day time frame. That hasn't changed. Now, if you have more than 250 employees, you should also be keeping a company record of processing, and that will need updating because at the moment it will quote, or should quote, the EU. Outside the EU, well, we know that 11 of the 12 countries that meet adequacy for the EU have actually said that, as far as they're concerned, the UK meets their data standards, and therefore we can exchange data with them without binding corporate rules and without standard contract clauses. There's currently no changes in the way UK businesses will send personal data to other countries deemed adequate by the EU and also Gibraltar. Gibraltar, by the way, if you've any connections or trading with Gibraltar, it's recognised as an extension of the UK, so UK GDPR. So what other actions are needed? Well, I would recommend to you do monitor in terms of adequacy, the adequacy ruling, and you can look at that on the EU website. I think you also ought to prepare a plan for updating your GDPR documentation to reflect UK GDPR. And you also need to check whether you import any personal data from Europe to see if you need to put, or you may potentially need to put in further safeguards if adequacy is not met. It's quite a nice little website here. I find the ICO website, which is very informative, is a little crowded. But there is a government guidance website here, gov.uk guidance using personal data after Brexit. They are providing updates on there, and I find that information relatively straightforward and doesn't waffle too much off the subject. So, ladies and gentlemen, that is an overview of the changes. They're not too horrendous, but there are things that you will need to do. Has anybody got any questions? The deadly silence indicates you're either baffled or satisfied.
Hi, it's Emma here. Sorry, my camera's not working, but we have a head office in Italy.
Yep.
Are they adequate or not?
So at the moment they are. Well, it's not them being adequate. So the EU will say that they meet adequacy, as all member states do. It's whether you meet adequacy or not. So if is that head office, Emma, for them?
Yes.
Yeah. So at the moment you can share data with them, and that's fine. If adequacy isn't met, though, in the next 6 months, you will need to move across to binding corporate rules because it's a corporate exchange of data. I would recommend that you actually have those forms filled in, just in case anything goes bump in the night. And there's nothing to stop you having them filled in and actually using them, because it doesn't place any more obligations on you than you already have anyway under EU GDPR and UK GDPR, but it just creates an element of certainty.
Okay, lovely, thank you.
You're welcome.
Well, I had a question, please, Philip.
Yeah, of course, Jonathan.
So I was interested to hear about MailChimp and third-party mail integration. I know HAE use MailChimp. We use one called ActiveCampaign, which is American.
Yep.
They have an office in Dublin as well. Can you just explain a bit more again about why you have to be careful there if you're putting data into that and then emailing, say, 1,000 people? What are the pitfalls?
Yeah. So the America is, or the United States, I should say, doesn't meet data adequacy. One of the reasons is that it's down to states to regulate the management of data. So in every EU country in the United Kingdom, the central government, the state, or I should say if you like, Parliament, in our case, takes control and regulates. In the States, it's totally different. And it's down to different states to regulate and uphold data subjects' rights. In California, they have a very robust regime. In the rest of America, it doesn't apply. So what the EU came up with originally was something called the Safe Harbour Agreement. And that was challenged in the courts in 2016 and failed. A new agreement was brought in, and that was fine, called a Privacy Shield. The Privacy Shield, and I fill these in for companies, not just in the UK, but in America, because I represent some clients in America as well. And the Privacy Shield is signed by, believe it or not, either the Department of Commerce or the Department of Transport, because there's no data protection authority that we would recognise here. So it's filled in by one of those two organisations. And a guy who's an Austrian called Max Schrimps, and you can Google this if you want, is a data geek and champion, decided to take Facebook to court. And it is rather apt at the moment, because in 2016, a UK company called Cambridge Analytica developed an app to process data from Facebook, and it could identify from Facebook anybody who they thought would vote Republican, and it pulled off Facebook tons and tons of data, which it subsequently sold to the Republican Party. And Cambridge Analytica weren't fussy. I think they've sold data to the Labour Party, they've certainly sold data to the Conservative Party in the past, and various others. And Cambridge Analytica, the name suggests, based in Cambridge, eventually a whistleblower blew the whistle on what was happening. The ICO turned up with a court order, because it was just pre-GDPR. They smashed the door down, I believe, took away a lot of documents in transit vehicles, and Cambridge Analytica filed for bankruptcy. But it left a legacy, and the legacy is that Facebook was sharing personal data that nobody knew was happening. And it was not just sharing the personal data, it was through Cambridge Analytica, they were flogging it to political parties. So this Max guy got very, very upset about this, and basically there was a court ruling in Dublin. There was also a court ruling by the European Court of Justice where it ended, and the European Court of Justice said that it was never safe to send data to America, effectively. It struck down the Privacy Shield. It said it was not safe, but it did rule that standard contract clauses was the only safe way of sending data. So even though you may have relatively modest amounts of personal identifiable data, you may only have an email address and somebody's name, that's still personal identifiable data. So if you are sending it for processing or anything else outside the EU, you must put in place either standard contract clauses or check that your supplier has got standard contract clauses in place. And if they haven't, these big organisations, you need to go to them and to say, and sometimes you have to have difficult conversations. I've had a difficult conversation on behalf of a client who's sending data to Australia to a processor, and it just doesn't meet adequacy, and I've had to say that. And they've now had, in the end, the suppliers actually had to set up a server in the UK to meet the standards.
Okay, well, I may speak to you after this meeting then about just checking how good we are there. Maybe we'll just do that direct with you and you take control of that, and we make sure we're correct. Yeah. Okay, thank you. No, you're welcome.
Philip, has MailChimp signed up to the standard contract clauses?
They have, you'll be pleased to know, because I thought I'd check that, because I anticipated you've been very diligent in asking me that question this morning. So what I would say on is, I can't download them for you. What that MailChimp requires you to do is to enter some account details on there as a European account, and then you can download those details. So just put MailChimp standard contract clauses into Google. It will take you to the relevant page. It will then ask you for some reference or your account number, and at that point it allows you to download them. But you do need to download them and put them on file.
Excellent. Okay. Thank you. And how can people check? Because obviously, you know, we'll have members that will use other data houses. So what's the best way to check?
The best way is to put the name of the supplier. I think Jonathan mentioned, was it Activate?
active campaign?
Active campaign, yeah, because there's lots of these, send in Blue and various other providers, and you just need to put the name in and then just put standard contract clauses and see whether that brings anything up. One of the problems I find with the American providers beyond the big companies, so Google have definitely done this because I've checked Microsoft, but some of the smaller companies waffle and say we are GDPR compliant and then have a whole page of garbage about GDPR and what you need to do and telling you the absolute obvious, which you all have to do anyway, but then it doesn't say how they meet the standards. And what the ruling on this is that American companies will struggle to meet the standards. So the only thing you can do is to get them to sign up to what's called codes of practice, and standard contract clauses are an example of a code of practice that is legally binding.
Okay. Thank you.
Good.
How long have we got before we could be potentially be prosecuted for not failing to comply?
So we have six months. We can continue to share data unlimitedly in terms of the EU. In terms of American companies, the ICO recognise that this has been quite turbulent. So they're simply saying at the moment, make sure you've got the right documentation in place, and if you haven't, don't share. The trigger's likely to come when some data subject gets quite miffed and somebody claims that their data has been abused. It's likely to come as a class action. So the more data you have, the more at risk you are. So just to be clear on this, the Information Commissioner's Office can challenge you, can fine you, and lead a prosecution. However, data subjects have also got the right to challenge things in court. So I'll ask a question here. Just put your hand up, because I see a lot of you on screen, or I'll put a thumb up or something. How many people have had an iPhone since before 2012? I think you have, Anne. I think we mentioned it. Yeah, Jonathan has. I certainly have. Right, so we're up at the moment. We're potentially up, even if you don't have an iPhone now, we're potentially up for compensation of £700 and odd. And the reason is, Jonathan's putting his thumbs up. The reason that is the case is that Apple shared data with Google, and it didn't put in place the right level of processing, and it didn't tell data subjects what it was doing. And there's a class action going on at the moment, and it's not quite got where it needs to go, but potentially you could be up for some compensation. And one of the things I always mention on the training course is Morrison's. Morrison's had a class action that they've had to fight at the Court of Appeal, and they had an auditor who decided to put all their past and present employees onto the internet. And the ICO said that Morrison's had done everything possible to protect the data, but they felt that the company had been diligent with what it had done. But nevertheless, this rogue auditor had put all these details on and has subsequently been prosecuted and gone to prison for it. But what the ICO said was that they were liable if there was a compensation claim to pay out on it. It went to court. The court upheld it. The High Court in the UK upheld it, but the Court of Appeal have overturned that decision. Otherwise, anybody who was past and present employee of Morrison's could potentially, for damages, because their personal data has been breached, claim compound. I think they were looking even at £1,000 each. For past and present employees of Morrison's, that's a lot of money.
Okay. Wow. So really, with UK GDPR, it's about personal data, personal email addresses, personal information. It's not about company information or company email addresses. So I guess for us, MailChimp, for marketing, MailChimp is our biggest concern. So that's good. And Google and Microsoft. So we've got those boxes ticked. I know there's some work to do on our privacy policy online, so we've got to look at that. But then for our members, they also need to be looking at HR software and accountancy software. So
yes. So just to refresh, in terms of personal data, in an extreme level, the High Court's rule that even an IP address can be personal information. People's names, so Anne at HAE is fine, but Anne Harrison or Anne.Harrison, suddenly your full name is there. So your full name. Now, you've chosen for corporate reasons, or you may have been compelled to use that, but you can well argue that that's personal data. So what the general idea on this is, if people have got Gmail accounts and it's got their full name in there, and I always quote the example of Jimmy the plumber at Gmail, we know that that's fine, but what about Jimmy.blogs at Gmail? That's obviously Jimmy's potentially private email account with his full name. So should you be mailing him there? So the general thought process is don't use what you believe to be private email addresses unless people have given you them, or you can demonstrate you've been given them. So if somebody's given you a business card and it's got their email address on there, they are giving you that for communication purposes, just as they're giving you that card with the name on, so you can communicate with them. So you don't need permission to seek permission, because it's deemed that you've been given that. But if you go around collecting things, or you've collected things and you're not sure where you've got them from, this is where companies get into problems.
Okay.
So I'm not condemning your database answer. I can see you looking worried there, but I would probably just do a search through there at Gmail accounts and have somebody like Annabelle or somebody else, or you can outsource it to us, to look through it and just check that you haven't got any full names in there at Gmail, that you've no reason, you've no grounds that you've got it. So if somebody came to the show and gave you the details, that's fine, but it's always having an idea of where you've got that data from.
I've got my own personal email addresses in there, but I have given that, I've subscribed to that, so and then it's okay, as long as we can prove when and where we took that information from. Yeah.
So, but you don't necessarily need to prove it. So this is where it gets complicated, and just to lighten it slightly, well, just to widen it slightly. So there's 6 lawful ways of processing personal data, one of which is consent, because you have consent. The second is contractual. You don't need permission if you've got a contractual relationship, as long as it's not marketing promotional stuff. So just to communicate factual information like you do to members, that's part of your service that you provide members. And that's one of the privileges of being a member. You do send out some very good briefing documents. So that's part of it, but you can also work on legitimate interests. So if you've got companies on there who you want them to join as members of HAE, because you're a business-to-business organisation, you're entitled under legitimate interest to reach out and communicate what you do, providing you give an opt-out.
Okay, thank you.
Philip, can I just ask a question? Can you hear me? It's Mark. Sorry, I can't get my camera working.
That's
so
all right, Mark. I was looking on the screen now. Yeah, I was looking for the mic there. Yeah.
Yeah, no, it's been very, very informative, and yeah, it's such a complex area. I was just thinking about our terms and conditions, which of course a lot of our members depend on as being the basis of their commercial transaction with their customers and clients. And I know that we keep this under constant review, but it sounds to me as though more than a tweak is probably required to make sure that we keep up to date with the changes around GDPR and data, personal data, corporate information, because there are various parts of the terms and conditions that are directly applicable to all this, I guess.
Yeah, so there's two things or three things really to it, and this is where it gets slightly confusing. So you've got your terms and conditions, and there may be things in the terms and conditions that you want to regulate what you do or explain what you do, but then you've also got separately your privacy policy, privacy notice, privacy statement, or privacy statement, however you want to pronounce these things. These are all the same documents. And this document sets out how you process personal data. So it's a separate document, and what the ruling is that you can't incorporate those into terms and conditions. They have to be treated separately. So in a way, that makes life slightly easier. But obviously, there will be things in the terms and conditions where you may say within your terms and conditions that that if you are a member, it's a condition of membership that we process your data in such and such a way. You can try and enforce that. There are issues with it, but you can set that out. So that's the first bit. The third bit, as part of that, we've also got cookies policies, And the cookies policy should not be within the, originally you could do this, but you could put it into the privacy notice, but you now have to treat that separately. So effectively, as a business, you've got 3 documents there. You've got your terms and conditions, and there may be odd things in there that you want to regulate or force people to do, which you certainly can do if you have a contractual relationship. You can say that what you'll do with their data as part of the contractual relationship. Secondly, you have got your privacy statement or policy or notice that tells people how you process their data and what legal grounds that you process their personal data on. And bear in mind, there may be more than sort of 2 or 3. So, you know, especially if it's staff, you know, vital interests. I don't need your consent to process your data if it's in your vital interest. And I've just called an ambulance because you passed out on the floor and I'm concerned. I'm entitled under vital interest to rummage through your pockets to see if there's any medical information there that could be useful to saving your life. So we've got that. So, and then we've also got the catch-all marketeers one, which is legitimate interests, and B2B is a lot easier. We're entitled to communicate what we do to people who we believe will be interested. And we can also use that if we're selling business to consumer, where we've got past customers, because we know we can work on legitimate interests. So we need to do that. And then finally, we've got cookies policy. And cookies policy is there's going to be more on this, but effectively what cookies we collect, how we process those, what we do with them, and how long we put cookie markers on with people's computers, etc.
Great, thanks for that.
You're welcome, Mark.